Okay, well, welcome everyone to our legal philosophy between state and transnational transnationalism seminar, our last one of the term. It's a real pleasure to introduce our speaker for today, Professor Margaret Martin from the Faculty of Law at Western. Professor Martin, Margaret, it's going to be hard for me to call her Professor Martin. Given that both Margaret and I studied philosophy together some years ago, not that long ago, but some years ago in Hamilton. Decades. Well, it's only one full decade, so I hate to use the plural. A while ago at McMaster University in Hamilton, where we met as master's students and where Margaret also earned her undergraduate degree. That was before going off to Cambridge, where she earned her doctorate, after which she returned to Canada, as she should, to the University of Toronto, where she earned her MLS, Masters of Legal Studies. She teaches and researches across a number of areas, including the philosophy of law and related areas in political theory, as well as constitutional law and international criminal law. She's published in some first-rate journals, including Jurisprudence and Criminal Law and Philosophy. And our very good book, Judging Positivism, was published 3 years ago, with Hart Publishing, in which it looks at some positivist themes and their, more importantly, their limits. So it's my great pleasure to have a friend and colleague now here with us today. Today she's going to talk about international criminal law, and specifically the International Criminal Court and the new Leviathan. So welcome, Margaret.
Well, thank you very much. So I'm thrilled to be here, and thank you for coming late in the term. And I'm also thrilled to be talking about international criminal law and the International Criminal Court. As Francois and Mike know, we also participate in a debate about the nature of law in analytic legal philosophy. And in that particular debate, we act as if the stakes are really, really high, but I'm not sure that they are. I think they are higher than people perceive them to be. But in the world of international criminal law, the stakes are immensely high. And we're dealing with life and death issues. So I'm really looking forward to talking about these issues with you today. I don't have a clear analytic framework that I apply to the problem. If you read the paper, you will know that what I do is I try to cast light on some of the moral issues that arise when the International Criminal Court navigates various contexts. And my aim is to draw attention to what I see are the moral obstacles that the International Criminal Court and the ad hoc tribunals encounter when we try to figure out if the court has justified authority. So this is the way that I proceed, and it's not exactly the way that other people proceed with this particular problem. And as the title signals, I draw upon the works of Thomas Hobbes, and I tell the conventional Hobbesian story, and I tell it simply to cast light on particular problems. So I'm not offering a new interpretation of the Leviathan or anything of that sort, but I want to use Hobbes in order to do several things. So let me lay out the simple Hobbesian narrative and then draw attention to the features of that narrative that I want to then employ throughout my paper. So the typical Hobbesian narrative is we are all in the state of nature, and as you know, it's a state of war of all against all. So we are in a constant state of insecurity. We don't know if or when our person or our property will be threatened by another. So in order to escape from this state of war, the state of uncertainty, and the state where we have no potential means by which to progress unless we leave this particular state. So to leave, Hobbes tells us, reason tells us that we have to leave the state of nature, we have to contract out, we have to form a social compact, and we give all of our rights to a single individual who is outside of that compact. And when that compact is formed, we then owe the sovereign obedience. So it's an act of will where we give up our rights and then we obey the sovereign as a result. The sovereign himself is outside of the social compact. So again, this is the typical story. But of course, consent for Hobbes isn't simply a matter of an act of will. Consent also has to be rational. There has to be a reason for people to consent. And the reason is that people will have a better chance of surviving long term if they leave the state of nature. So it's rational to consent because the risks that you face will be reduced. Of course, the sovereign remains in the state of nature, and in the state of nature, it means that he is a continuous threat. But Hobbes says it's better to have a single enemy than many, many, many enemies. So the entire Leviathan, in my view, on the typical straightforward reading, turns on risk assessment. So it's better to leave the state of nature because it's riskier to stay because you may not survive. So life is nasty, brutish, and short, to use the familiar quotation. So that's the familiar narrative. And the reason that I try to use this narrative in this paper is I want to cast light on certain features of international criminal law as it is applied internationally. And one feature is the nature of authority as an unbounded authority. So in reference to Hobbes, his sovereign is unbounded. He is not below the law, he is above the law. We often think of the International Criminal Court as an institution that is bringing about global justice. So we tend not to think of it as an institution that is an unbounded power that potentially is an unbounded, dangerous power. But I actually think it is potentially an unbounded power and a dangerous one at that. And to access this particular idea, we can think about the idea of a good global citizen or a good Canadian citizen. So if I'm going to be a good Canadian citizen, I will, I hope, abide by Canadian law and take moral and legal responsibility, hopefully, for the foreseeable but unintended consequences of my actions. And I don't think that the International Criminal Court takes responsibility for the foreseeable but unintended consequences of its actions. And the foreseeable and unintended consequences of its actions often involve putting the most vulnerable people in the world at greater risk. And this is what I find particularly worrying. So I'll move back to Hobbes in a moment, but I'll give you an example. The example that I use in my paper pertains to al-Bashir. So the ICC in 2008 announced that it was going to issue an arrest warrant for al-Bashir. And al-Bashir responded and he said, well, if you issue that arrest warrant, I am going to get rid of all of the aid agencies that are working on the ground in Sudan. I'm going to exile them, I'm going to revoke their licenses. And the UN reported that actually when the court issued the arrest warrant in 2009, all of the aid agencies were indeed expelled from Sudan. And the result of this was that 300,000 people were made more vulnerable. So we don't know exactly what happened to them. And it's a short-term problem, but it's a long-term problem as well, because it's very difficult for these aid agencies to return to that particular country because the bonds of trust have been broken. So the single act by the prosecutor destroyed a lot of the good work that was going on the ground in Sudan. So I worry that they are not taking responsibility for the consequences of their actions in their pursuit of the narrow ideal of legal justice. And in reference to this particular example, it's also problematic because they aren't going to be able to arrest a sitting leader. And of course, recently, as a number of you might know, 3 African nations have threatened to withdraw from the ICC precisely because of problems that have arisen because the ICC is issuing arrest warrants for sitting leaders. So the upside of taking that action isn't clear, but the downside, at least in this particular case, is very clear. And what I want to really stress is that we're not just talking about that typical dichotomy between peace and justice. So I'm not simply worried about pursuing justice over peace. I'm actually also worried about the nature of that dichotomy as it's articulated. Because when you forward the argument that we're going to pursue justice regardless of whether peace is impacted in a given situation, what's missing there is a sense of the kinds of injustices that are perpetrated by the ICC itself. I'm not suggesting that it doesn't do good work, but I am suggesting that it doesn't take enough responsibility for the unintended consequences of its actions. And one of the claims I make in the paper is I say that the dichotomy between peace and justice makes it seem as if you can choose one of the moral gladiators and root for them. But actually, if you look closely, once the ICC makes certain choices, it itself becomes an agent of injustice. And we shouldn't just assume that legal justice defines the sphere of justice and that we can support all of the actions that it takes. Now, one might argue that, of course, the ICC doesn't have to issue arrest warrants for sitting leaders. So this might be one way around this problem. So this is a contingent feature of the practice. But I worry also that the lens that they have adopted is particularly narrow. They're pursuing legal justice as they define it. And so the unbounded nature of authority is clear, I think, from this particular example, even if there are instances where the ICC or any of the ad hoc tribunals do bring about good results on the ground. So if I return to my big question, which I lay out in the paper, the big question is it rational to consent to the ICC, to be bound by the Rome Statute? Is it rational for states to give up a degree of sovereignty in the name of international criminal justice? And in this paper, I want to say, no, it's not necessarily rational for them to do so, because it's unclear in advance what kinds of gains will accompany that choice. Okay, so it might help a given country, but it might not. And I frame the question in terms of good rulers. So if rulers are interested in making sure that the people that are within their country are kept made safe and their security interests are provided for, if they're interested in the best interests of their population, then they should hesitate before consenting to be bound by the ICC. So that's the large claim I want to make. So if we return to Hobbes, Hobbes is not just an act of will, it's a reasonable act of will. And I don't think it's reasonable to give up sovereignty for unpredictable results. So that's the central claim. Now, I don't think things necessarily improve if we move from the question of who's being arrested to the actual situation where a trial takes place. And this leads me to my next example, which, and in this case, I look to the works of Mark Drummel. And Mark Drummel works on questions dealing with the Rwandan genocide. And in the particular example that I use, I point to the slaughter of 2,000 people in a parish. And in this case, what happened was an official was appointed and he oversaw the slaughter. So he stood by and witnessed the slaughter. He was eventually arrested and convicted of crimes against humanity, but his sentence was only 15 years. So if we're dealing with some of the worst crimes that we could possibly commit on this planet, and the sentence is only 15 years, there seems to be a disconnect. Mark Drummel explains this disconnect by pointing to the nature of genocide itself. He argues that the atrocity, the terrible nature of the atrocity seems to implicate certain agents, but actually the way that the atrocity occurs in the group dimension takes away culpability. So there's this interesting paradox, he calls it a paradox within genocide itself. But in this particular case, it was criticized heavily by the prosecutor in Rwanda, and the point was about the nature of local norms. He said that, in fact, if you took local norms seriously, everyone on the ground understood and knew that this official was acting in an authoritative fashion, and he did, in fact, oversee and partake in this particular genocide. So passively watching in the context of the Rwandan society amounts to actively encouraging, if you understood the local norms, okay? So the court was faced with a difficult choice. They had to either recognize the Western understanding of authority or the Rwandan understanding of authority. And the choice was between a local contextual conception of authority or a universal one. They call it universal, but I don't think it is universal or could be universal. And they opted for the universal standard, the Western standard, so the sentence was low. And they defended this, or the idea behind this is that if the court is going to create precedents for future trials, they have to appeal to universal norms. They can't turn to local contingent norms because that would turn the jurisprudence into a local contingent set of norms that couldn't be applied in advance. So if the court wants to deter future people from committing these acts, or if they want to realize any of their institutional goals, like creating a new normative order, they're going to prioritize the universal over the particular. And notice that here, I'm of course pushing for them to prioritize the local over the universal, partly because I don't think the universal exists. The moment that they just have to make that choice, it reveals that the idea of universal itself is an illusion, and you have to make a choice. And the choice, in my view, should be to try to do something for the society that is suffering. So the court should work to implement norms that make sense in the context in which the crimes took place. So I'm advocating for that. But I want to say that I'm not trying to defend a pluralistic conception of justice. The way this plays out in this particular case is the local conception of authority gives us access to the idea of legal culpability. So we're trying to figure out culpability. So I'm still using that universal, so-called universal Western standard of legal culpability, but I'm using a local norm to access the level of culpability. Okay, so I'm not trying to defend a pluralistic theory of justice, and I hope I don't have to, but I'm certainly not trying to do that here. And in this particular context, we can then re-ask the question, should leaders consent to be bound by the Rome Statute? And if we look at this particular case, we see that the trial itself becomes an instrument by which the court is able to articulate so-called universal norms. So the individuals involved becomes a means to the end as envisioned by the court itself. And I don't think that it's rational to consent to be bound by the Rome Statute if you can expect that you will be treated as a means to some other end. And if I pull a quote from the British common law context, so Lord Hewitt says, justice must not only be done, it must manifestly and undoubtedly be seen to be done. And if justice isn't seen to be done on the ground in Rwanda, then any of the goods that might emerge from the trial, the transitional justice goods, such as healing a fractured society or giving people a sense of closure, all of those goods are lost if you pursue the universal over the particular. And of course, the universal is, in my view, an illusion. So in every particular context, when you try to apply that universal norm, it might lead to the need to appeal to particular norms of that community. So I worry that the court is treating particular societies and particular cases and particular sets of victims as means to their own institutional ends, and they're not focusing enough on the needs of the communities in question. So again, for me, what's at the forefront of any of these international tribunals or even organizations is, do they help or hinder the lives of the most vulnerable? And again, I'm afraid that the International Criminal Court is on the wrong side of that particular divide. So let me give you yet another example, and I'll go back to Hobbes once more. So with Hobbes, another reason that I turn to Hobbes is because the narrative of global justice has captured the imaginations of a whole generation. And that particular narrative has the ICC at the center. And there's some real intuitive pull. So if we can find these guys and prosecute them and hold them accountable, it seems like it's the morally right thing to do. And regardless of if there's some foreseeable but unintended consequences that accompany this, it just seems as if we should be doing this. So as Sarah Nowen points out, it's almost as if global justice and the ICC have become a single narrative. Their stories are one. And so I thought, well, I need another narrative that's quite powerful to challenge the global justice narrative, and Hobbes is my guy. So what Hobbes does, I think, is he paints a picture of the state that is fairly scary. And it's not particularly inviting, as Michael Oakeshott points out. He almost turns the ideal of a civil society into a hell. And so it repels us. And I like that. So Hobbes is repelling us. And I think the things that the ICC are doing should repel us as well. So when the ICC aligns itself with states that are oppressive in order to pursue particular criminals who are rebels in particular societies and committed atrocities, when they align themselves with states, in those particular cases, they are actually aligning themselves with rulers that are scarier than Hobbes' sovereign. Because remember, Hobbes' sovereign, as Hobbes presents him to us, is worried about, or not worried about, not worried about anything, but Hobbes himself is worried about protection and individual security and survival. And so you enter into the state because you have a better chance at surviving. Now, in the context of an oppressive regime, you might have, in the real world, you have situations where minorities are oppressed. And when these minorities are oppressed, they're living in a constant state of fear, and probably fear that their lives are at risk. And when the ICC aligns itself with those particular rulers, they're contributing to that situation. They're reifying, glorifying, stabilizing wicked regimes that I think are scarier than Hobbes's particular account. And so we shouldn't think of the work of the ICC as forwarding global justice unless that's the conclusion of a detailed argument, but it can't be the assumption going in. We have to look at the particular context to see exactly what's happening on the ground in reference to the trial, in reference to legal standards, and in reference to the foreseeable but unintended consequences of the legal action. And I note in my paper that Hobbes himself doesn't talk about the relationship between the sovereign and potential minority groups. And I suggest that this is a blind spot in Hobbes's account, but it's a blind spot that he's well aware of. So he's, at the same time as being a political scientist, he's a social architect, and he's trying to get people to reimagine themselves. So he abstracts away all sources of difference, whether it's cultural, social, economic, all sorts of differences are no longer part of his understanding of the individual. The individual is the isolated agent, and this isolated agent is equal to all other agents. So it's an ideal of equality that informs his theory, so we reimagine ourselves in a particular way. With the ICC in the real world, of course, we don't have the Hobbesian isolated individual, and we don't all see each other as equals, and the state doesn't necessarily see groups as equal to each other. So we have the risk of systematic oppression. And the political theorist John Donne notes that he's not convinced, for instance, that the African American population in the US owes obedience to the government because they aren't being given protection by the government. So the Hobbesian model breaks down when we find groups of people that aren't being given the adequate level of protection. So again, I worry that when the ICC aligns itself with wicked rulers in the pursuit of partial justice, and then they define victims in terms of the victims that fall on a certain side of an ethno-cultural divide, that not only is the ICC reifying that divide and possibly solidifying it, it's working on the wrong side of justice, at least for that particular set of vulnerable individuals, okay? So again, I wanna say that Hobbes's Leviathan is scary, but some of the things that the ICC is doing, they're scarier. And that should be a counterweight, hopefully, to the narrative, the happy narrative of global justice. Now, there's one final point I want to make before I open up the floor to questions, and it's a case that I've talked about in forums before, and it's a case that people have a lot of strong opinions about. So it's Erdemovich, and this, I'll explain the facts of that case in a moment, but this speaks to the first quotation that I open with from Fred McGray. So, international criminal justice cannot by fiat, or create by fiat, a world that would make sense of its existence. It must make sense of its existence in the world as it is. So international criminal practitioners, so lawyers, they must make sense of the human condition. They can't recreate it in an image that doesn't connect to the common motivators and drives that we all share. And so I think Hobbes, in one sense, is a master of understanding what drives human beings, at least in part. And in the world of international law, I don't think they've quite captured this, and they seem to have lost touch with common motivators and common reasons for action. So let me lay out the facts of Erdemovich, and then I'll say a few words, and then we'll open up the floor for questions. So Erdemovich was a low-ranking soldier in the Serbian army, and he unwittingly participated in the massacre at Srebrenica. And he afterwards turned himself in, said he felt very guilty for killing, I think it was 70 men and boys on that particular day. And there was some discussion as to whether or not they should proceed, but they decided to prosecute him, and they found him guilty. But the fact that's of interest to us is the fact that if he had resisted, he would have been killed. And a gentleman, one of his colleagues, did resist and was killed. So the question on the table was whether duress could serve as a complete defense for crimes against humanity. And the dissenting Justice Cassese, said, no, we have to, law can only do so much. Law governs the reasonable expectations that we have when we live collectively together. It can't expect us to become a martyr for the sake of the law. But the majority, so Voorhees and McDonald, they make a very different claim. And they argue that we, as international lawyers, have to articulate a set of universal norms, and these norms should deter combatants from performing these acts in the first place. And they want these norms to change the way that people act. They want to give people new reasons for action. But of course, these new reasons for action seem to have little power in the real world context. And Hobbes would say, well, why would anyone want to give up their life for the sake of law? And I would agree. And I would agree with Cassese. Why would anyone die in order to live in accordance with international criminal law? And that is certainly my worry about that case. And they said they don't want anyone to use the defense as a way to escape from liability. But of course, if they live according to the law, they'll be dead. So they won't need the defense. So it creates this curious situation going forward. And either they're offering us a utopian or dystopian understanding of the human condition, whereby legal norms, international legal norms, becomes quasi-religious in nature, and they're supposed to govern our lives in this curious way, or they simply want to generate guilty verdicts, and they don't care if people can't follow the law in advance. So you have this problem, and once again, they're using a particular case to generate institutional or to achieve institutional goals. They're not assessing culpability, in my view, in the way that I think they should be. They're simply trying to achieve some of their goals, and Erdemovich becomes the means to that end. And they admit that they've shifted their attention away from him and towards the political policy goals of the institution, and they make this explicit. And the one other thing about this case that troubles me is that when you pull back the curtains and look at the power dynamics that set up the tragedy itself, we find that the US and a lot of the superpowers had a policy of peace at all costs. So a tell-all was written by Frances Hartman a couple of years ago, and she said that the CIA watched the slaughter in live time and they didn't do anything about it, and they knew it was coming. And of course, we all know that the Dutch left and abandoned the people in the safe zone, and that led to the following action. And when you pull back the curtains, you can see that Erdemovich barely had any power, yet he's now guilty of crimes against humanity. Those who had power fund the ICC and set up the trial, and they look like the neutral party or the good party who's bringing justice to the world. So when we ask about where the power dynamic is coming from and who's suffering and who's gaining, I think the picture becomes a lot more complicated. And I'm not sure if all of these problems can be solved. I think the court can do better. And if it can't do better, I don't even know how or whether it should proceed as it's going. So that's I'll stop it there because I'm curious what you have to say about my potentially controversial paper. Thank you.
Okay, great. Thanks very much. Okay, so now I have lots of times for questions. Yes.
Thank you so much for the presentation. It's definitely a very interesting point of view. My name is Adelina Iptemne. I'm a postdoc here at Osgood. I have two questions. One of them, I was wondering specifically regarding the ICC, if you can envision in any way a manner in which it can take responsibility for the effects of its actions in a manner that would align it morally to the theory that you use to analyze its frame. And because without having read your paper, I'm sorry, it just seemed that thinking of an institution that has such kind of universal jurisdiction or wants to have such a universal jurisdiction, I'm not sure that this kind of alignment would ever be possible. And secondly, I was wondering how your analyses, or to what extent your analyses would apply to hybrid courts, because I mean they do have certain advantages over international or ad hoc courts, and they are more aligned to the local culture and local legal tradition, but they also have so many elements of the international criminal justice sphere. So I was just wondering how you see that analysis.
Yeah, thank you. So in reference to hybrid courts, I think hybrid courts are potentially much better from a moral perspective than their international counterparts, because they can be more responsive to the local context, and you also remove the institutional aims that are implicit in the ICC project, the aim of articulating universal norms that are always going to be applied in advance. So a lot of these aims, which I think are potentially damaging and morally problematic, I think they disappear in that context. So I'm happier with the hybrid tribunals. In terms of whether the ICC can be reformed or whether these problems that I'm worried about can be mitigated at all, it's an interesting question. I think there are a number of potential avenues that we could proceed down. And one of the things that I think about there's a difference between the contingent issues and those that are embedded and structural within the very idea of international law. So issuing an arrest warrant for a sitting leader, that's a contingent thing. They don't have to do that, and they certainly don't have to do that in any particular case. So that the decision of who to arrest and why is central to my worries, and I think they made the wrong decision in that case for the reasons I mentioned. But some of the problems that arise are very much structural issues. So the fact that whenever the ICC enters into a conflict where you have two sides and it's an ethno-cultural conflict, often the victims on one side are recognized as victims and the victims on the other side aren't. And then if you want to heal a broken society, you've actually entrenched the very divide that might have caused the problem in the first place. So you have particular effects that the court can have that are negative because of the very nature of law. So in general, what I would encourage the court to do is to broaden the scope. So under Section 53 of the Rome Statute, they allow the interests of justice to impact on decisions that are made, who to prosecute, etc. And when they issued in 2007, I think, when the Office of the Prosecutor issued a treatise on peace and justice, they said, we are just concerned with the legal issues. We want to look at the entire situation through the legal lens, and governmental organizations can deal with the social aspects of a wider, broader conception of justice. That's not a legal document insofar as it's not binding, but it tells us what the court is up to. And notice that in my first example, in the document, they presuppose that they will work side by side with aid agencies to make sure that life is better on the ground for people. In the example I gave you with al-Bashir, they were working against the aid agencies. And as anyone who's worked with aid agencies knows, it's very hard to help people who are very poor if you're trying to achieve that end, if you're trying to make sure that they have a better life going forward. It's hard, but when you have a powerful international organization working against that end, it's almost impossible. So they're assuming that they will be working hand in hand with these other organizations, but in fact, they don't always. So what I would encourage legal practitioners to do is to think broadly about the variables and not to simply approach the problem with that narrow legal lens. And I don't think all the problems go away, but at least they can do better in future.
Thank you so much for this presentation. I'm not sure I have a question, but I probably have a comment.
Sure.
So first, it's a comment about the division between various public authorities. So if you draw a parallel between HOPS and the ICC, so I was wondering whether there's any analogy to some division between executive, judicial, and the legislative authority, right? When Hobbes talks about sovereign, he probably has in mind the sovereign, the executive, And at the end of the day, ICC is a judicial authority which actually adjudicate the case. So I just was wondering whether this division between these three public institutions actually creates any problem, conceptual problem to your analysis. And actually, I have a further comment. It would be an analogy between your first example of al-Bashir. I think, sorry, al-Bashir was second example. But anyway, the al-Bashir example and the problem of accountability of domestic courts, right? Because it seems to me there's to be some similarity of a problem of domestic courts. And in terms of domestic courts, for instance, I know I'm fairly familiar with the topic of restitution of taxes, right? So we have a domestic court which deals with the problem of restitution of taxes. It's a private law issue to be dealt with under the law of restitution, the law of unjust enrichment. And then we have a question of accountability. What will happen after the court decides according to traditional doctrines, right? So we might maybe decision of the court will lead to great to the chaos, financial chaos of domestic authorities, and some systems actually adopted so-called special defenses, public authorities. Other systems rejected them. We have so-called pass-on doctrine. So it seems to be actually a problem of domestic courts as well, right? A problem of accountability. A problem of judicial process, according to which the courts actually struggle to follow certain formalistic paths, right, as opposed to actual consequences of their decisions. Thank you.
Yeah. So in reference to the second question, I do take your point that I think some of the problems I mentioned arise in the domestic context as well, which raises another issue which I touch upon briefly in the paper, which is the shadow of imperialism, right? So at least in the domestic context, you have a host of institutions working together to achieve certain ends. And in the international context, you have this court that is planted in a certain context, and it has its own institutional ends that are divorced from the ends of the people. So if the question is, do we ever escape the possibility of having a so-called uncommanded commander and an unchecked exercise of power? Probably not. But then the question becomes, well, do you want to cede sovereignty for this external court to come into your country in order to and potentially pursue its own institutional ends? So because there's a potential choice to make about signing or withdrawing from the Rome Statute, I think that question can be asked, but I do take your point, and I think I have to address that point a little with more detail in the paper. And that point relates to the previous one, which is about the conceptual layout of the paper, because of course Hobbes is thinking about the executive and the ICC is a court. And I touch upon that briefly because I don't see the whole problem of moral authority through a doctrinal lens. And in that sense, I do agree with you, though I have to draw a few more distinctions. For the International Court, my worry is that it seems to be something other than what it is. So it's because it's a judge acting and not the executive, it seems to be an instrument of justice. And so it's that appearance that I worry about. But in terms of, and also it's the pure exercise of power, and the fact that that exercise of power takes away from sovereignty of the domestic state, which in some cases might be a good thing, but not in all cases, and this is what I worry about. So it's that relationship between sovereignty and security that allows me, I think, to connect those two ideas. And I agree that I have to do a little more work about mapping out the conceptual scheme. And in the paper, I do mention that the Rome Statute is about states consenting to be bound, not individuals. So in Hobbes's world, it's individuals that consent to be bound by the sovereign. And so there are a lot of conceptual moves that I have to be very careful about. But in general, I worry about the exercise of power and the vulnerability of individuals. And that's why I want to translate Hobbes's account into the international sphere. But I do take both points. They're very good. Thank you.
Thank you.
Just terms I was not too sure. I thought it was very thought-provoking. Actually, I have many thoughts. I'm going to put a few on the table. The first is that I worry about using the Leviathan as a kind of sort of exemplar against which to evaluate the International Criminal Court, especially with respect to the case of the ICC going after leaders of ongoing conflicts. Because in those situations, it's not that the ICC is acting as a Leviathan, is providing safety and this kind of environment where life is no longer nasty, brutish, and short. It still is, right? So it's just playing a role, sort of stopping impunity. You're trying to express something within this, but it doesn't claim to resolve everything, right? The whole literature on transitional justice, Colleen Murphy's new book at Illinois is about this, saying, you know, transitional justice is this big kind of set of circumstances which could be translated in different kinds of circumstances of justice than normal kinds of stable states where we might more think of the Leviathan as being a proper kind of way of understanding the source of political obligation and so on and so forth. It's also the case that the ICC is subject to, yes, it's a creature of the consents of states, at least initially, but then there is the United Nations Security Council that can just stop everything and then decide to compel it to scrutinize the behavior of leaders of states that are not parties of ICC. So I just wonder about the place of the Leviathan given these kinds of circumstances. So that's my first point. The second one, you kind of alluded to it. You kind of alluded to it by mentioning done, but you asked at the beginning, is it rational for states to give up sovereignty to the ICC? And you say no, because it's not clear what they would give up their sovereignty for, right? So they give up their sovereignty for unpredictable results. And then a bit like Sagi, I'm left thinking about Anglo-American criminal law jurisdictions and the amount of discretion that exists at the domestic level, right? The police can decide to charge, you know, whoever they want in the end. Prosecutors can then, when there are police charges, at least in Anglo-American jurisdictions, decide to drop charges or change them at the last minute. And certain groups are going to be more affected than others. You might say, well, for those groups, actually predictable. You know, if you happen to be driving while black, or if you happen to be Aboriginal in certain regions in Canada, that might make it predictable. But it seems to me that the unpredictability is more radical than this. So in this sense, is the ICC very different from domestic jurisdictions like the ones we're familiar with? It might be that your criticism is also applicable to the domestic sphere, and I have no problem with that. I actually think there would be something to be said for that. But that's just a thought. And finally, I think there are resources in Hobbes for youth to think about how to behave versus the ICC in light of the predicament that you point out. Because Hobbes says, yes, if the Leviathan has been consented to, at least hypothetically, people have an obligation to obey him. But then, as Alice Ristroff points out in a lot of her work on Hobbes and criminal justice, it's still the case that Hobbes recognizes that individual can resist punishment, despite the fact that they have. So there's a kind of a bit of an oxymoron within Hobbesian theory itself. And for Ristroff, that, I don't want to call it right of resistance, but basically that's what it is. She says, well, that's kind of articulated in the context of domestic trial as, for example, the privilege against self-incrimination, the right to full answer and defense, and these kinds of protections that are built in within this, the criminal justice system itself, the criminal system itself. But it seems to me that your discussion of Herdimovich seems to say, well, in international criminal law, that's just not there. Even though we have certain kinds of protections akin to those of the domestic, that are present at the domestic level, the context is such that by preventing certain kinds of defenses, you're just basically, you know, confining people to their own death, and that's terrible in a way that wouldn't necessarily parallel the domestic context. Anyway, just some thoughts.
Yeah, no, those are very good questions. So the first question, why Hobbes?
Yeah.
So you're right, of course, and I think I mentioned it in the paper, but I'm not sure. The Security Council can go after anybody whether or not they signed, but I'm still isolating that question, partly because South Africa and two other African nations are deciding to withdraw, and there's a crisis in the court, and people think this is illegitimate, and I think it's potentially legitimate. And my point isn't, so the examples that you put forward, I think the ICC might be able to do very good work in a number of contexts, and perhaps especially when life is nasty, brutish, and short, and they might be one tool that's used in a particular context. And if that's so, then it's great, but I would like to see more situations where it's one tool used in a context where the end game the end result is good for the people on the ground. And I'm not yet convinced, and I follow Sarah Nowen and Fred McGray and their skepticism on that point. But as a counterexample, I'm trying to point to examples that demonstrate that the outcome for vulnerable people is going to be unpredictable, and you can't trust the court to work for their good. And I think the court should be working for their good. And I think when you mentioned the discretion that prosecutors have, I think they should use that discretion. So for instance, when the people of Uganda wanted to negotiate with Joseph Kony and the rebels, and then Luis Moreno Ocampo said, well, we're not going to let you negotiate, because as soon as he arrives at the negotiating table, we're going to arrest him. And so they're not able to come to an agreement with the Lord's Resistance Army because of the prosecutors' threatened interference. But in that case, you might say, well, maybe they should let the people on the ground determine their future and withdraw the arrest warrant. So they don't seem willing to move in that direction. Once they issue the arrest warrant, they tend to keep it in place. And so I'd be happy if they exercised their discretion in a way that was responsive to the needs and concerns articulated by the groups on the ground. And I don't think they're doing that. So I take your point that that the ICC can do good works, and discretion can be used in a variety of ways, both in the domestic and the international context. But I'm still worried that it's not being used enough with the good of the people in mind. And so it can always, in another way to put it, your point about international and domestic, I don't see the fracturing of the interests of the institution as clearly in the domestic context. So in the domestic context, the courts work alongside, the criminal courts work alongside other courts, and you have a whole socioeconomic context. And I think I might idealize the domestic context a little too much. I don't talk about it enough.
I mean, you speak to some Black Lives Matter people.
Right.
Yeah.
No, exactly. So I nod in the direction of John Dunn on that point, but I might idealize it. But in the international context, the institutional goals of pursuing or achieving some level of deterrence for future criminals, setting universal standards for action, those particular aims seem to part ways with the other aims: healing a broken community, making sure that justice is done in a particular for a particular group of people, like my examples illustrate. So when those two sets of goals split, I prefer the one set over the other, but you can't guarantee in advance that they're not going to pursue the institutional ones. Where in the domestic context, once you convict an individual of a crime, it expresses to the community that that act is wrong. You have the retributivist aim served insofar as innocents aren't punished, etc. So all of the potential aims of the criminal law are served at once, and in addition to the underlying good of, once you serve those norms, potentially at least, you're able to maintain the safety and security of the community, so they don't come apart in the same way. So I worry about the fracturing of the goals when they're applied in the international context, and I don't worry about it in the same way at the domestic context, but I certainly take your point that I don't talk enough about the way that my critique would reflect back on the domestic context, and I think that's a section that I should add, in fact, precisely for the reasons you mentioned.
And the business about resistance, I guess I would just
Oh, pardon me? Oh, the point about resistance. Sorry, I missed that. So for Hobbes, the reason you enter into the state is to protect the possibility for survival. And so he argues, as you know, in the Leviathan, that nobody ever actually gives up that right. So we're matter in motion. The motion doesn't want to stop moving, so we never sacrifice that right. Have you read Cromartie and Skinner, their discussion of Hobbes's final work, they note that Hobbes doesn't talk about this particular right to resistance, and they suggest that perhaps he doesn't talk about this because he recognizes the critiques were quite powerful early on, and if you have the right to resist and you have the right to determine under what conditions you can resist, the entire edifice might collapse. So there's an internal tension, as you point out. And in reference to the way it operates at the level of the International Criminal Court, if the question is, would I be happy if people like Rademovich had the right to resistance, or I would, and I think that survival has to still be at the center of legal thinking and thinking from the perspective of transitional justice. And when you lose sight of the ideal of survival and that potential right of resistance, then you lose more than you think. And the institution can't function unless it recognizes that that is one of the primary drivers for individuals. But as I was listening to you mention that point, I think it's a nice way, if I can think of a way to incorporate that point into the paper and give it another level of sophistication, I think that would be an interesting move to make.
So I was a bit nervous at the beginning when you said you didn't have an analytical framework that you were going to use. So the analytical legal theorist in me, my radar went off.
And then she said Leviathan.
I'm not sure I'd use that as an analytical framework, but as opposed to an account of political legitimacy. But you might just on that, you might even say that if the ICC fails a Hobbesian test of legitimacy, that's pretty bad because that's setting the bar quite low.
And that's what, that was my point. Yeah.
Because you can imagine sort of social contract theories which have much more demanding standards of justice, which the ICC would fail, or would plausibly be thought to fail. But if it's a Hobbesian test that it fails, then there could be quite a bit of, that wasn't my question, but I thought that was, that would be one answer. Look, it's really bad if it's not passing that bar. But so on analytical frameworks, though, so I was much more comfortable when I detected one, as an analytical theorist looks to do in cases. And I think I think there's a good one there. So this is not one that I'm suggesting, but one that I'm attributing to your paper. So just as you were explaining it, and in the paper as well. So you drew a analytical distinction between features of international criminal law, but in particular the International Criminal Court, which you could say are contingent features. They're features which we could reform. So, for example, not issuing arrests for sitting leaders, maybe changing the use of duress as a defense for murder. Maybe Mark Drumble's work on, he's got quite interesting stuff on, acting wrongly, acting, in participation in genocides. Tends to look quite different from murdering in domestic situations, because in many situations such as Rwanda, participating in genocide is not deviant in the sense that a criminal wrongdoing in a domestic state is. So you're actually fulfilling the norms of your legal system or your legal order. Now, of course, there are those who will object to that type of conduct, but it's not deviant in the same way. So you might say that there's an argument for reforming that contingent bit. Maybe we should reform the ways in which duress is used as a defense for certain crimes, and those, on the one hand, would be contingent features that could be reformed, but they're not, as you said, they may not be structural issues. So analytically, we might want to distinguish those contingent parts, which, if reformed, would not be a transformation of the International Criminal Court, but they would be reformed. We just tinker with some of tinker is a quite light way of putting it, but we change the basic rules. Whereas a structural issue would be quite different. If you had to address that, then the International Criminal Court might look quite different. And here, just to get here's the question, or the suggestion maybe, to try and attribute an analytical framework, is that there might be something about the jurisdiction of the International Criminal Court which could be useful in identifying structural core problems with the court. So if you think about its jurisdiction as one in which it will only act if the home state or the domestic state institutions are unable or unwilling to act. And so you might think, well, what's presumed? What are the presumptions behind a complementary jurisdiction where a court will only act if the domestic courts are unable or unwilling to act? A presumption might be that there must be some quite radically problematic character to that domestic situation if the domestic courts are unwilling or unable to act. Maybe Bashir's still sitting as leader, and that makes it unwilling or unable to act. But that might just be an example. That might not be a contingent feature, but might actually be pointing to something a bit deeper. And so you might think, well, if a court only has jurisdiction to act when the domestic courts are unable or unwilling, then you've already got a situation where an external international body might have significant difficulties, unlike those domestic courts face. And that jurisdiction itself might be the kind of paradoxical problem, which might need a structural or a core change to the institution, which would transform it. So I don't know. I mean, there's a suggestion the analytical framework is let's parse out the contingent from the structural issues because they're going to require different types of responses. And so your analytical framework then sets up the sort of moral and political work that needs to be done. And then the suggestion is maybe it's jurisdiction. It's a structural core issue that needs to be rethought. I don't know how you do that without redefining maybe out of existence the International Criminal Court, but that seems to be a big structural problem or obstacle.
Yeah, that's very helpful. The principle of complementarity. So if domestic courts are unwilling or unable to prosecute individuals, then the international court can take over. That it's an interesting principle, and it makes sense, I think, in the abstract. On the ground, what it means in some cases, especially when domestic systems refer a case to the court, is that they can actually use it as a political tool. So that's another worry I have with complementarity on the ground. But in general, I think you're right. If I'm going to offer a theory whereby I try to improve the status quo, I would have to deal with that basic idea of jurisdiction. And I do think it's useful to separate out the contingent from the necessary features of the International Criminal Court. One of the features that I can't decide if it's contingent or necessary is the various purposes that the ICC pursues. So even though it strikes me as something that can be changed, they don't have to give priority to their institutional goals over and above the needs of a given populace. It seems like it's a feature of the institution that is unlikely to change. So even though it's contingent, it's one that seems very firm and embedded in the institution itself. So I worry about that. In the context of my paper, just to take it back there, one of the arguments I don't mention is the argument I begin with. And what I try to do is set up the possibility that the ICC can do better. And some of the ways it can do better are the ways that you listed. But some issues are, I think, entrenched, and I worry about those particular issues. One of the points of resistance, which I noticed in the field of international criminal law, is that people say, well, we can't fix this, so we're always going to have the problem of victor's justice, and we're always going to have the problem of peace versus justice. These problems don't go away, so let's just soldier on. That seems to be the attitude of a lot of the practitioners that I encounter. Well, we can't fix it. We can only aim at partial justice. We can only do a limited amount of things in a limited amount of time in a particular context. But then my worry, of course, is that the effects of that action might be quite dire on vulnerable populations. So I want to counter any desire just to proceed as they are already proceeding. And then the question becomes how to best articulate that, and whether I'm hoping that my paper doesn't lead me to the conclusion that I have to say the court has to disappear as a moral matter. I'm hoping to find a way to say that we can think about these issues, and we can offer some ways forward for the court without suggesting that the moral problems are so entrenched that we should just do away with it, which is one of the possibilities that you mentioned.
I wonder, just on that last bit, that's interesting. I mean, why not? Why not? I mean, there is this argument out there which says that if the International Criminal Court were completely successful, so a success rate of 100%, it would have no work to do, because the threat or the risk of internal civil wars and conflicts actually being taken over by an international institution, that potentiality would encourage, lead, influence domestic courts and institutions to take care of their problems in a way which doesn't draw attention internationally from the International Criminal Court. I don't know if that means it would disappear. It might be still useful as a kind of an institution of record, an institution providing support on criminal procedures and maybe with nuances across cultures and so on. So it might take on a very different kind of character. and disappear as a criminal court. I don't know.
But on that argument, it presupposes that it's successful in achieving its aims of
Right.
creating an incentive structure whereby leaders behave in a certain way, where I'm doubtful that that world order will come to pass. But if it did, of course, I'd be very happy about it. The question is what to do in the meantime, and whether my argument leads me down a path where I have to say it's, after I deal with some of the complexities raised, that it's an institution that has too many moral hazards that it can't possibly justify its moral claim to authority. But so yeah, I still worry about that. And I do think institutions, I do think it can do good work, and especially in contexts where it's localized. I do like the hybrid model much better. And if we can move towards that model, I would worry a lot less about some of these problems.
Yeah, John?
If nobody else is going to go, I'll risk rambling, because that's what I'm tempted to do right now. I'm sympathetic to your project, and it's been thought provoking, because I've been sitting here thinking what I think about it, and partly it's directed to Hobbes. It's been a while since I give Hobbes a good long look, but whenever I hear the part of Hobbes that talks about the consent of the governed, I think that's not the most plausible part of Hobbes. Because when we punish a murderer, it's not because they went back on their word. It's because they murdered, right? I mean, breach of contract is in the grand scheme of things not that big a deal.
Right.
And so that theory never seems to have any plausibility to me, right? Like when I analyze it, I tend to think in terms of of governing collectivities and everybody else, or everything else, right? So I mean, the governing collectivity, if that's a meaningful phrase, and it is a vague one in practice, right? They don't need consent; they just need acquiescence. Okay, that's all they really need, right? And it's really illustrated in emergency situations, right? Where there's a rebellion or something like that, and it's a question of how do we deal with the rebellion, right? Well, you prosecute a certain number of people viciously, but you don't prosecute everybody that was involved. Otherwise, you won't be able to keep a lid on the thing. You just prosecute, you try to prosecute exactly the right number of people that the lid goes back down, right? And doesn't boil off, come off the top of the pot. You just need enough to settle it down again, right? Mm-hmm. And it's the same thing with routine law enforcement in a place like Canada, right? And it's always interesting to see one of the difficult things in a governing collectivity is different roles of different participants, right? And that's the relationship between courts and other agents of government. So the Supreme Court of Canada notices, right, that it's taking ridiculous amounts of time for things to come to trial, okay? And so they say, well, so some of these charges just have to be thrown out, right? And what that illustrates, but what the Supreme Court of Canada can't do is put more resources into the system and say, well, there are going to be more judges, and we're going to do that, and there are going to be more prosecutors, and we're going to do that, and there are going to be more police, we're going to do that. So that's somebody else's job, and the Supreme Court of Canada doesn't try to do that part of the job.
It can render judgment, like in the case of Jordan, which it did last year, and say, a reasonable time for a trial is 30 months. If you don't do that, you're innocent. And then you're having all the governments across the country now panicking
and wondering what they're going to do.
Exactly.
But the Supreme Court, so it's a governing collectivity, right? But no court manages resources, and they're not designed to do it, right? So that there has to be a certain level of teamwork within the governing collectivity, and how they assign their individual roles is an interesting question. But generally speaking, courts are not designed to lead that project. And that finally gets me back to the International Court, right? Mm-hmm. I mean, assuming that some governing collectivity of nations decides, look, what's going on in Africa just sucks. Let's get together and do something about it. I mean, it smells of colonialism, which of course is the political problem that there isn't out. But that's the project. It has to be a group of nations that's saying, look, they're not running things properly. Let's us get together and run it for them, right? That's the project. But the ICC doesn't have the resources to carry that project forward, and they're very much at risk of being very out of whack with the people that would put those resources in. And again, you don't need the consent of the governed, okay? All you need is their acquiescence. And you ask yourself, why does a country like Canada agree to be part of the ICC. Well, it's because we don't think it's ever going to apply to us. Right?
Right.
That's the practical political reason, and it sounds like a good thing. It will sound like we care about the world and all that kind of stuff. But we don't really think it's ever going to be applied to us.
Right.
Right. That's why Canada is a party to it. But the countries that are getting the blunt end of the system, they're the ones that are saying, should we be acquiescing in this? And the answer is probably not, unless they want to buy into being colonized by somebody else. I mean, that's how I analyze it anyway.
Yeah, so in reference to your first point about Hobbes and consent, I probably agree with you that consent isn't as important for the reasons you mentioned in the domestic context, but I think it does do some work in this particular context, notwithstanding the Security Council's ability to prosecute people who haven't consented. But if it's the question of should we consent to be bound by the Rome Statute, I think the answer might be no. And in reference to your point about the role of courts, of course, I take that point as well, and that's the defense of the institution. We can't do everything. We can only do this narrow thing, and we can only do it as well as we can, given the resources that we have. And you mentioned teamwork between different institutions. So if they cooperated with a host of institutions to make sure that the work that they were doing did not put lives at risk, then I would be in favor of the work that they were doing. But there isn't a lot of necessarily teamwork depending on the context. And I also appreciate the work of, I mentioned Sarah now, and she's a lecturer at Cambridge, and she wrote a paper recently about the role of victims. And of all the statements taken, because often the ICC and the various ad hoc tribunals make the claims in the name of victims. We're actually going in for the sake of the victims to bring justice to the victims. But only 5 victim statements have ever made it into court, and 3 were thrown out. And so of all the victims' points of view that are collected, very few make it up the hierarchy. And so I worry about the victims' voices from that perspective, and also just in general in terms of their well-being after the fact. And if there was teamwork on the ground, I'd be more sympathetic if they were prosecuting individuals that weren't simply of African origin or as they are these days, then I'd be less worried. I share your concerns, and that was a very helpful intervention. Thank you.
Well, the court seems to have made a move recently, at least at the office of the prosecutor, to go after the U.S., right? Given what happened in Afghanistan. So that might just be the kind of counterpoint that you're looking at.
Yeah, and I think that's really interesting. And I think if the court, so then it raises a number of questions about complementarity. Of course, we're going to have to see how that plays out. But I think if they have a broader set of people that they pursue, this will help. I'll be more comfortable with that. But I still, I still worry. And one of the things I am trying to think about, because I know, Francois, you write about that you rely on theories that I'm not referring to here. I'm also trying to think about which theories of domestic law apply in a way that could potentially offer me some resources whereby I can say something more positive about the work of the ICC in addition to raising these fears. But perhaps my paper just leads to worrisome conclusions at the moment anyways.
It seems to be the direction of the criminal law scholarship in general.
Yeah.
I think of Rick Wong.
Yeah, there are probably a couple of parts to that could be quite interesting. The first one is exactly which particular elements of domestic criminal law have been kind of transplanted or adopted, and are they sufficiently culturally sensitive? And then the second, the more positive construction would be, well, which elements of domestic criminal law ought to be used that haven't been, and potentially are there new features that we don't have in domestic criminal justice systems, which would be good. That's a huge question, but it's kind of a neat analytical, philosophical question as well that would be good to pursue.
Yeah, and I think the first step would be taking my critique and reflecting it back on the U.S., and that would give me an entrance point into the broader question, at least for the...
Keith Wellman came to give us a lecture a few years back. on the question of whether the United States criminal justice system is a crime against humanity in and of itself, right? So there seems to be that kind of discussion. It's interesting because it's might be worth looking at that lecture again. Yeah, I think it's important.
She might have given the same lecture at Western.
Oh, but there you go.
Yeah, but I missed it. I was away. But yeah. Well, thank you.
Okay. There are no further questions. Just thank our speaker.
Thank you.
Great. Thank you,
Thank you
Margaret.
very much.